Good afternoon, everyone. Can you hear me? Yes?
Yes, we can, Judge.
Oh, fantastic. Are you ready to go for this afternoon session? Thumbs up?
Sure am, Judge. Yep.
Fabulous. That's the way to do it. Okay, so when I call your name, please come forward. First, I have William Andrew Toulos.
Mr. Toulouse, come on. Oh, he just stepped out right now. He's speaking with pretrial.
Oh, okay, no problem. I'll pass.
Yes,
Wendy
ma'am.
Aguirre.
I believe I've been advised she bonded, Judge.
Okay, thank you. And for the record, I would have found probable cause. And Luz Mary Diaz.
North Broward, Judge.
Thanks. Luz Mary Diaz for North Broward. Anybody there?
What happened to the first two?
Okay. It looks like we're gonna have to
Bonded.
pass.
Okay.
You were on the phone with them?
Yeah.
Oh, nobody's at North Broward yet.
Judge, Mr. Andrew Toulouse actually came back. I don't know if you want to readdress
Sure, of
him.
course.
Okay.
Absolutely. And
Thank you.
is it Mr. Toulouse? Toulouse?
That's fine. Yes, that's
Okay,
fine.
thank you, sir. You've been arrested on one count of aggravated battery on a pregnant victim. I have reviewed the arrest affidavit, and I do find probable cause for the arrest. There is a bond. If I could just get a little bit of guidance from the parties with regards to bond. I'll first hear from the state.
Yes, Your Honor. Based on the level of violence in the allegations, and also Mr. Toulouse has a previous conviction for possession of firearm by convicted felon. That was from 2010. Purchase of cocaine from 89. State is going to be requesting a $7,500 bond and no victim contact.
And defense?
Judge, in speaking of Mr. Toulouse, he's been residing in South Florida since 1989. He is 53 years old. He's currently employed. He works at the Fort Lauderdale swap shop in their maintenance department. He's been working for them, for the same company, for over 27 years. He's making
Which one?
$17.
Is that the Sunrise Boulevard swap shop?
Yes, ma'am.
Yes, Judge. He's basically no money in the bank, no property. His mother just passed away. I believe it was in February this year.
Yes, that's
So
correct.
unfortunately, there's no family on the outside to post his bond. I believe the alleged victim, which is the niece, does not reside with him, so there's not going to be any sort of problem as far as him adhering to no contact with the alleged victim. Considering his strong ties to the community, his lack of financial resources, Judge, we'd be asking to impose a $2,000 bond on Mr. Toulouse's behalf.
Okay. I was actually thinking that I was thinking of 3,500.
May I say something?
Now, I know Mr. Toulouse is going to say financially he cannot come up with any sort of bond right now because he doesn't have anyone post it. And the alternative, he's asking if you would consider pretrial release.
That's fine.
Well, why did when you suggested $2,000, who was going to post that?
Burglary happened in December.
No, I was thinking because of his finances as far as making $17. However, in speaking with Mr. Toulouse right now, when he did advise me that his mom passed away, he's also telling me he has no other family member to post his bond. So financially, now he's telling me that nobody can post his bond.
Well, I'm not. Is the pretrial release officer?
Okay.
Okay.
Sure.
So,
All right.
is this? I'm not really comfortable with an offense like this, considering his
Okay.
priors. Is that a disqualifier? The priors? So I just want to clarify something, just so you know I'm listening to you, and I am listening to you, of course. And not only is this offense a disqualifier, but that prior offense is a disqualifier to pretrial release. So I'll go ahead and set the bond at $3,500, no contact, direct or indirect, and hopefully he could come up with some ideas. All right, thank you.
Yes, Judge. Thank you.
Counsel, did you have something? No?
Actually, I was going to wait till you take a break so I could talk to the PD about a case from this morning. They didn't have the PC. I can get from them.
Oh, okay.
Oh, did you already? All right, I'm sorry then. That's fine then.
All right, sure.
Thanks.
And then LaShawn Jennifer Russell.
Ms. Russell is here present at main judge. Come on up, Ms. Russell.
Did I do anything to you? I'm so sorry. Ms. Russell, first of all, I think you have a case in my regular division. That's number one. But number two, I have reviewed. Strike that. It looks like there's state. Maybe you could. Oh, I'm so sorry. Finish what you're doing.
Of course. I'm sorry.
If you can just help me a little bit with regards to Ms. Russell's.
Sure. Yes. Judge.
It looks like there's a number of capiases and maybe some potential change of charges. I'm not really exactly sure. If you could help translate this for me.
Sure. Counts 1 and 2.
She's in my division.
Yeah, that's what I thought.
On the first
One
count.
and 2 are just are failure to appear capiases. 3 through 6 are from a not in custody.
Same thing as this morning.
Yes. We just filed it when she wasn't in custody.
Okay, so let me go ahead and then review that with her. There's 2 capiases for dealing in stolen property, and there are bonds on each one of those counts. That's counts 3, counts 4. They're both bonds of $3,500 each. Also, there's counts 5 and count 6. Has to do with false owner information for pawned items less than $300. Each of those felony counts carries a bond of $1,000. So, is that it? 6?
Yeah, that's all.
Okay. So when you put the bonds together for all these counts, you get, let's see, 6, 7, 8, 9, $9,250 in total bonds.
Judge, if the defense could be heard, and speaking with Ms. Russell, I was trying to let her know what was going on. She advised me that financially she cannot post bond on any of the counts. She advised me that she was just...
I would just simply say, just so you know, she's at risk of potential bond revocation in my division.
My understanding, Judge, is she was in front of Judge Singal. This is what she told me. I don't know if the state can verify. She was just in front of Judge Singal, and she would just resolve the case, and she's currently was placed on probation. None of these offenses basically happened after probation. It happened before she was on probation. So she's going to be supervised by the department. So she's requesting, Judge, if you would consider an ROR on her behalf because she's going to be supervised by the department.
No way.
Now, my understanding, Judge, on count 2, she currently has a no bond hold. In the alternative, would Your Honor consider giving a bond on count 2? And the reason why I say this is when I was looking through Odyssey, she had private counsel. She had a person by the name of Don Morrison. Your Honor signed a motion, basically granting that private counsel's motion to withdraw, and on that same day, you went ahead and issued a capias for her arrest. I don't see where she was actually noticed for that court date, which would have been March 21st, 2017.
She
wasn't there present.
She was noticed.
When I looked in Odyssey, I didn't see the notice.
I clarified it in court. I always do. It's part of the standard of practice. Yeah, it's just part of a standard of practice. I don't issue capiases unless we verify notice.
I just didn't see it in Odyssey.
I'm not saying
that
she
private
got
counsel,
it. I'm just saying we're showing there was notice. Do you see the difference?
Okay.
That's a standard.
I understand.
That's a standard of practice. So anyway, that's the story, and I don't know anything about her resolving a case in Judge Singal's. All right.
Yeah.
All right. Thank you very much.
Thank you.
Alexandra Gainey.
Okay.
Oh, sorry. I'll get it.
Sorry,
Just
I
keep
thought
telling.
you asked if that was that right there.
Ms. Gainey, come on up. Gainey's approaching, Judge.
Thank you. And ma'am, this is, you've been arrested on one count of grand theft. Just for the record, I did find probable cause. You do have a bond. It's set at $1,000.
And, Your Honor,
Yes, sir.
I'm going to ask, because it appears that at least the addresses I'm showing are the same, that there be an order of no victim contact.
Okay, thank you. And I'm ordering no victim contact, no return to that location, no contact, direct, indirect, with the alleged victim in this case.
Thank you, Judge.
Judge Lerner,
Yes?
we skipped over Mary Diaz.
No, we didn't. When I called for her, nobody was there. So
No,
I
I
have
was here.
to
I was
circle
putting guys
back.
in the cell.
No worries. I'll come back. Hi.
Okay.
I'm back.
Jokes. I like that one. I'll give you that one.
I'm back. Voila. That was
right.
easy. So is she there?
Yeah, she's right here.
Oh, sorry.
Come on in.
No, I'd love to see her.
I'm not her.
I knew that. I knew that. I knew that. No issues. Hi, Miss Diaz.
Hello.
Hi. Just for the record, this is a magistrate proceeding, and I just wanted to let you know, first of all, that you have been arrested. I know you know that, on one count of driving while license suspended or revoked. I did find probable cause. And essentially, you also have violation of probation hearings before your division judge. You are going to see your division judge on May 8th. I believe that's a Monday at 8:45. So, and those are no bonds. All right, thank you.
Thank you.
You're welcome. Thank you. Sarah Ivana Herrera.
She's a probation judge. She declined to serve as public defender. My understanding, she has private counsel, Mr. Eric Rudenberg.
Okay. Thank you, ma'am. And just for the record, you have been arrested on one count of battery on a law enforcement officer, 2 counts of resisting or obstructing without violence, and there is a pending violation of probation. This triggered a violation of probation matter. So that is a no bond hold. I did find probable cause on all counts. You will be seeing your division judge on May 3rd, which I believe is Wednesday at 8:30, and your bonds as to count 1, the battery on a law enforcement officer, I will set at, what is that bond? Is it 500, 700? What is it?
Well, I mean, I was probably going to be asking for a little more, only considering that she's on probation for battering against a law enforcement officer.
Oh. I'll set, okay, thank you, I didn't realize that. I'll set bond on count 1 at $1,000, and bonds on 2 and 3 I'll let stand. All right, at no bond, at
Well, no, she needs a bond on count 2.
the bond, okay,
I mean, you can do whatever you want, just something has to be said.
understood. I'll set it, on
Just make sure you explain it when you're in there if you have issues.
$50 on each count. But it looks like there's a $100 bond actually
That's
on count 3.
That's the convenience bond on count 3. The count 2 is the one that just has to be said.
Okay, so do 100 on count 2. Just keep
Okay.
it simple. All right, thank you very much. Good luck. And Marcial Aguirre, waiting for the Spanish interpreter still. Marcial Aguirre,
I've been advised, Mr. Aguirre bonded, Judge.
thank you. Bernard Davis.
Come on in.
North Broward.
Thank
North
you.
Broward, Your Honor.
Thank you very much. Mr.
How you doing,
Davis, good morning. Good
Yes,
morning.
ma'am.
Good afternoon. How you doing?
I'm doing so good so far, ma'am.
Okay, sir, you've been arrested on 1 count of trespass allegedly at a McDonald's. If you'd like to resolve your case this afternoon by way of a plea of no contest, you can. The offer of sentence is a withholding of adjudication, no conviction, and no return to that McDonald's.
Okay, man, that'll be fine.
Can you stand up for me, please? So I can see
Sorry,
you?
miss, sorry. Yes, ma'am. Can you see me now?
Yes, I can. I appreciate that very much.
Okay, yes, ma'am.
So it's a withholding of adjudication, no conviction, and no return to that McDonald's. Understood?
Yes, ma'am.
All right, thank you very much. You're all set. Thank you. You'll be released.
Okay, thank you. Thank you, ma'am. Thank you, everyone.
Judge, I don't know if, have we had an opportunity to address Mr. Anthony McIntosh? That was, I believe, one gentleman for Mr. Hernandez or Marcial Aguirre.
No, I did not. Hello.
Spanish interpreter.
Okay, very good. All right, so then have a seat so far.
Anthony I could do that.
Okay, cool. Mr. McIntosh, come on up.
And, Your Honor, just assuming the court finds PC, just some information I'd want to provide you before you
Sure,
set up
give me
bonds.
1 second.
Of course.
Okay, thank you. I have reviewed the probable cause affidavit, just for the record. And I did find probable cause on both. I'm just waiting for him to come into the screen.
Oh, is that Maine? Maine.
Oh, Maine, sorry, hi, sorry.
Hi.
Got wrong places. Okay. So, first of all, you have been arrested on 1 count of domestic violence, injunction, willful violation, and as well as 1 count of possession of cannabis misdemeanor. I did find probable cause as to both counts. And sir, what did you want to say?
First, Your Honor, I wanted to advise the court, Mr. McIntosh was arrested in 2015 and 2011 for battery. He was, both cases were dropped. It appears the 2015 case was domestic in nature. Additionally, Your Honor, I pulled the, and a final order of protection was issued in this matter on count 2. I pulled the alleged victim's petition, Your Honor, because I just wanted to be able to provide some specific information what was alleged. And, Your Honor, she describes previous violence against her, stating that Mr. McIntosh grabbed her from by her neck from behind, aggressively forced her to the ground, dragged her by her arms through the apartment, kneed her in her chest, put his nails into her face, drug her back into the den, and then to the ground for. So, like I said, I just wanted to advise the court some of the alleged violence from the alleged victim.
Judge, and speaking of Mr. McIntosh,
I'm confused. Could I just?
yeah.
I just want to apologize. The original, the underlying, there may be a mistake. I'm not sure, because I'm not connecting the PC affidavit to what you're saying. The underlying affidavit petition for protective order was in whose name? As the petitioner?
Devon Heller.
Okay, is that a man?
A male.
It's a male.
Okay.
Devon.
Yes.
It's a male.
And that's who's listed. It's
Okay, thank you.
contacted the. Yeah.
And can you just repeat that for me,
Yes, Your Honor.
please?
Mr. Heller alleges on a previous incident that Mr. McIntosh grabbed him by his neck from behind, forced him to the ground. As Mr. Heller tried to cover his face, trying to protect himself, he started to drag Mr. Heller by his arms to the apartment. At one point, he attempted to roll over and get back to his feet, and Mr. McIntosh quickly kneed him in the chest. He was holding his chest, gasping for air. At that point, Mr. McIntosh put his nails into Mr. Heller's face and drug him back down to the ground. Mr. Heller claims he was trying to defend himself. One moment, Your Honor. He notes prior to this incident, whenever the two of them had a disagreement, Mr. McIntosh tells him, "This is my warning. He isn't afraid to put Mr. Heller in his place."
What was the date of that?
The petition was, he sought the injunction, Your Honor.
Or when was it issued?
Okay, he sought it January 3rd of this year. The final injunction was issued January 12th. Sure, January 12th of this year.
Okay. And what is your recommending? What are you recommending?
Your Honor, I'm going to be requesting a $5,000 bond and a GPS monitor because of the combination of the both, Your Honor.
Reasonable. Okay.
Judge,
Yes.
in speaking with Mr. McIntosh, basically he's been residing now in South Florida for 1 year. He is employed. He works at an attorney's office in collections. He's been working for that office for about 5 months now, making approximately $12 an hour. He does have, he's going to be living separate and apart from the alleged victim on count 2. He'll be residing with his friend who resides in Miami Gardens. Financially, has no money in the bank, no property. Judge, we'd be asking you to consider a $1,000 bond on count 2 and leave the standard bond as to count 1, $100.
Thank you. I'll set bond at $5,000 with GPS, no return, no contact, full compliance with the protective order. Thank you very much. So he'll be under supervision of pretrial release upon his release. Sir, could I swear you in, please?
No, don't worry about that.
Do you
last
solemnly
one. This
swear
is
from
a-
the interpret from English to Spanish, Spanish to English, pursuant to a proper correct rendering from this court to the best of your ability?
I do, Your Honor. Igor Felicioni, F as in Frank, Elicioni.
Thank you very much. We had a few matters from this morning's docket.
Correct.
And then we were going to do a recall. So does anybody have that paperwork? From this morning, it was Coronado.
Coronado Rodriguez.
He's here at Maine.
Thank you.
Could you call it speaker?
Thank you very much. So we'll start then with Mr. Coronado. And what did I do?
Vamos a iniciar con el señor Coronado.
Good afternoon, sir.
Buenas tardes, señor.
And
Good afternoon, how are you?
I'm great, thank you
Estoy
for
bien, gracias.
asking.
Por preguntar.
1 second, please.
Un segundo, por favor.
Is that right? What are you looking for? I don't know what you're looking for. Here, why don't you go through this and see if there's anything here you want. And, sir, just for the record, this is a magistrate first appearance hearing.
Señor, para los efectos del acta, esta es una primera aparición frente al magistrado.
It's a very limited hearing,
Es una audiencia bastante limitada.
and I'm here to advise you of your bond,
Estoy aquí para informarle acerca de su fianza
and also whether the court finds probable cause for your detention.
y también por si la corte halla que hay causa probable
You
para su
have,
detención.
you have been arrested
Usted ha sido arrestado
for 1 count
en un cargo
of battery,
de agresión,
domestic violence.
violencia doméstica.
I have reviewed the arrest affidavit,
He revisado la declaración de arresto
and I did find probable cause.
y hallo que hay causa probable.
Also, just for the record,
También para los efectos del
I
acta,
found the arrest affidavit disturbing.
hallé que la declaración sobre el arresto fue bastante perturbante.
I'm interested in bond recommendations
¿Hay alguna
and any
recomendación de
prior.
fianza y algún crimen previo?
Your Honor, I didn't see any criminal history. I don't know if pretrial release has any
Su señoría, no vi nada
additional
acerca
information.
Because you don't have the NCIC
historia criminal, antecedentes
capability.
criminal. No sé si la gente de liberación prejuicio tenga algo.
Thank you.
He just wasn't on my list.
Yeah.
Your Honor, that being said, based on the level of violence alleged,
Habiendo hecho esto, su señoría, basándonos en el nivel de violencia alegada,
specifically biting the alleged victim and leaving teeth marks on her wrist,
específicamente morder a la víctima, a la supuesta víctima y dejar marcas de dientes en las muñecas
then slamming her to the ground by her hair,
y luego lanzarla hacia el suelo mediante su pelo.
the state is requesting a $7,500 bond and a GPS monitor.
La fiscalía solicita una fianza de $7,500 y un monitor
Sí.
GPS.
Anything from defense?
¿La defensa tiene algo que
Judge.
decir?
Go ahead, I'm listening to you.
He's 34 years old. This is his first arrest. He resides in Dade County. He's currently working in construction. He makes approximately $12.50 an hour.
Su señoría, él es un hombre de 34 años, es su primer arresto. Él actualmente reside en el condado de Dade, trabaja en construcción y aproximadamente hace $12.50 a
I
la
have a
hora.
question for pretrial release in terms of the jurisdictional aspects. I'm not sure you can do GPS out of county. Oh, can you do it anywhere?
Not anywhere, but Tri-County, I believe we can.
Tri-county, you can.
Judge,
Yes?
if I could just,
Oh, there you are.
he does reside in with the alleged victim. He does understand he'll have to remain separate and apart. He'll be residing with a friend of his that also lives, who lives in Dade County as well.
Thanks for
But he'll be
clarifying
living
that.
separate. We'd be respectfully requesting a bond of $2,000.
Bond is set at $5,000.
There's nothing to say.
Absolutely no contact, direct, indirect, with the alleged victim. In the event he bonds out, he is going to be supervised by pretrial release on GPS. Absolutely no contact, direct or indirect, with the alleged victim.
La fianza se fija en $2,000. No podrá tener contacto directo o indirecto con la víctima alegada en caso de que llegare a pagar la fianza. Él se encontrará bajo supervisión del oficial de liberación prejuicio y va a tener que tener un monitor GPS y absolutamente no podrá tener ningún tipo de contacto con la víctima alegada, directo o indirecto.
Thank you.
Gracias.
Thank you very much. There was, who else for the interpreter?
Pablo,
Yes.
Pablo Ospina.
Yes, yes.
Senor Ospina?
Pablo Centeno Ospina.
He's here, main judge.
Thank you. Sir, you have been charged with and state, tell me if this is the right, if I'm saying this correctly. I haven't seen it stated, this classification of crime. Promotion of sexual activity of a victim less than 16 years of age.
Señor, usted está siendo cargado con promoción de un acto sexual con una víctima menor de 16 años.
For the record,
Para el acta,
I reviewed the arrest affidavit.
he revisado el reporte del arresto.
I do find probable cause.
Hallo que hay causa probable.
I would appoint a guardian ad litem on behalf of the alleged victim.
Le nombraré un guardián ad litem a nombre de la víctima.
I would set bond at $15,000.
Fijaré la fianza en $15,000.
Absolutely no contact
No podrán tener contacto en absoluto
Direct.
con la víctima,
or indirect
directo o indirecto,
with the alleged victim.
con la supuesta víctima.
In the event he bonds out,
En el caso de que llegara a pagar la fianza,
I am ordering him under the supervision of pretrial release,
ordeno que esté bajo la supervisión de
under
un oficial
GPS
de
monitoring.
liberación prejuicio y utilizando un monitor GPS.
And do I need a range?
I'm sorry, Your
Do I
Honor.
need a scope? Huh?
Yes, I do. And, Your Honor,
Sure. What?
let me answer first. So, Your Honor is inquiring as far as the radius with the GPS monitor. Your Honor, my understanding, you can extend it as pretty much as far as you want within reason. You're not limited to 500 feet.
Right. So 5 miles?
Let me just check one thing, Your Honor.
My only issue is, if I start getting into constitutional issues and
If you'd like, Your Honor, what I could do, because I see they both reside in Pembroke Pines. If you give me a second, what I could do is put both addresses into the computer to see if I can get a distance that the two homes are apart from, and that might be able to give you a better idea of what you want to do with regards to that.
fine.
Okay.
Judge, while the state is looking for that information, if the defense could be heard.
Yes.
Judge, in speaking Mr. Ospina, he's been residing in South Florida for 4 years. He is 25 years old. He's currently employed. He works at a restaurant as a cook. He's only making $11 an hour. This is his first arrest ever in his life. Judge, if the state can confirm that, he lives in Pembroke Pines with his father. We'd be asking you to reduce the monetary bond. Therefore, I believe pre-trial with the GPS monitor would alleviate any of the court's concerns. But monetarily, the bond that's presently, that Your Honor has ruled upon is financially out of reach for Mr. Ospina.
Thank you. Denied.
Señoría, el señor Ospina ha vivido en este condado por 4 años, tiene 25 años de edad. Él trabaja en un restaurante como un cocinero, hace $11 la hora. Ese es su primer arresto. Él vive en Pembroke Pines con su padre. Lo que le pediríamos respetuosamente es que bajara la cantidad monetaria de la fianza. Estaremos dispuestos a que él tenga un GPS para aliviar cualquier duda que pueda tener el juicio. Le pediríamos por favor que bajara el monto de la fianza, monto denegado.
Your Honor, from what I can see here, using different routes, it's showing about 3.84 miles. The listed homes are apart from one another. If you wanted to set a mile, if you wanted to set 500 yards, I think that would still give him the ability to reroute so he could move freely and not come within the distance of
So
the
500
home.
yards?
I'm fine with that, Your Honor.
Fine, 500 yards.
One other issue, Your Honor, I would ask
Yes.
about, and I don't, if the court, guys, if you could inquire, if Mr. Ospina Sentinel has a passport.
Sir, do you have a passport?
Señor, ¿usted tiene un pasaporte?
Sí, señora.
Yes, ma'am.
Your Honor, I would be asking also for a requirement that Mr. Ospina Sentinel's passport be surrendered to the clerk of the court prior to his release from custody.
Meaning that he's a flight risk.
I have a concern. I'm showing he was born in Colombia. Certainly he's facing, and I believe the courts have held that the court, even facing significant consequences, even with no priors. If convicted of this offense, he faces potential serious consequences. I think that is enough that there's be cause for concern that Mr. Ospina
I would order
Sentinel.
the surrender of the passport.
And I apologize for not stopping to let you translate. Let
Do
me
you want to
just-
repeat?
I'll
Why don't
just
we?
say-
I'm fine. Su señoría, hay una inquietud acerca de la naturaleza del crimen. En este momento le pediríamos la posibilidad de que si el señor Ospina pudiera entregar su pasaporte al secretario de la Corte, visto que nosotros consideramos que es un riesgo de escape, vista la naturaleza de los crímenes y la potencial consecuencias de dichos crímenes, y como la persona nació en Colombia, le solicitaríamos a la Corte que por favor ordenara que el señor Ospina entregara su pasaporte.
Judge, we'd be requesting that if Your Honor orders that special condition, that he be allowed to surrender within 48 hours of his release.
Yeah, I am.
Si eso fuera ordenado, pediríamos que él se le pidieran entregar ese pasaporte 48 horas después de su liberación.
Your Honor, I would argue that potentially defeats the entire purpose by potentially giving someone a 48-hour head start upon release.
Yeah, I agree.
Pues eso realmente derrota el propósito de que él entregue el pasaporte. Sencillamente le estamos dando 48 horas para que se pueda ir. Sí, estoy de acuerdo.
I agree. I think he should surrender his passport within 3 hours of his release.
Él debe entregar su pasaporte 3 horas
think that's
después
very
de su
reasonable.
liberación. Considero que eso es bastante razonable.
Thank you, Judge.
Gracias.
Oh,
Gracias, juez.
This is where we'll run into a problem. 3 hours after his release, surrender a passport. If he gets released from custody at 8 p.m. at night, who's he going to surrender to that passport? 3 hours gives us.
It's
another
fine,
3
just
hours.
coordinate but the thing is, you can't coordinate the release because you don't know if a bond is going to be posted.
Well,
Let him
I'm
talk,
sorry.
please.
Please go ahead.
El problema que vamos a encontrar es que si el señor es liberado, por ejemplo, a las 8 de la noche, y en una ventana de 3 horas, ¿a quién le va a entregar ese pasaporte? ¿Quién lo va a recibir? Eso está bien, lo podemos coordinar.
And, Your Honor, that's why I'm asking that the surrender be done prior to release.
But how is that gonna
Por eso estoy
happen?
pidiendo que se entregue el
If you could
pasaporte antes de
explain
su
that to me.
liberación.
I will. Your Honor, what he can do either through a family member or bondsman at any time, take his passport to the clerk's office. So you can, they will give a receipt based on the court's order that they've received his passport. And when he's ready to bond out, they bring that receipt to the jail.
Okay, so I order that a family member or surrogate delivers it to the clerk's office
Pudiera hacer el
prior to
señor,
his
lo que pudiera
release.
hacer el señor es
That makes more sense to me. Sure.
lo que pudiera hacer el señor es mediante algún familiar
Cortas.
o alguna persona o algún funcionario para dicho fin entregar ese pasaporte, enviar ese pasaporte a una oficina de la corte en donde le darán un recibo conducente sobre la orden de la corte y cuando él pague la fianza podrá.
Sure does. All right, thank you very much.
Ok, muchas gracias.
Is that it for the Spanish defendant?
No, there's one on the second look docket.
Okay. Who would that
Acevedo.
be?
Acevedo.
Thank you.
Acevedo. Come on in, Miss Acevedo. Come on. Yep, right here. Stand here. Got a Spanish interpreter.
Judge,
Yes?
on Mr. Ospino, would you sign a phone order allowing him access to his phone contact so he can call his father?
Of course I would.
Si le
Thank
otorgo
you.
la orden del teléfono.
Who is this on?
Vacito, right? Vacito?
Viciedo.
Vicito.
Viciedo con B corta.
The one we just did. On the I don't have any paperwork for the second look docket. Do I?
Just if you want to look them over, these are the felonies and misdemeanor. Almost all the felonies, I think, except for one, are motions to release. Okay, all. Exactly.
Oh, here's. I think this The what?
That's the second one.
The front page? I don't know if I had a front page for that. Not all of them had a front page for some reason.
Frankly, I think they can charge him someone.
I don't have it.
Section 13.
Okay, on the second look docket,
Yeah.
En el expediente de segunda revisión.
there you go. Thank you.
Did you call over to SBU? Oh, okay.
I have Alexander Brock.
Well, wait, what?
Alexander Brock.
I believe in Conti, Judge.
Judge Loren, are we going to do Facito, Spanish?
I'd like to. Yes, we will. Mr. Brock, give me 2 seconds.
Not a problem.
Hello. There we are. And I just don't have the paperwork, so maybe somebody could help me.
Just 1 second. Jez, do you have a copy of the report, initial report?
I just don't have this woman's PC affidavit for some reason. Thank you. Thank you very much. This says Johan Lazaro Ramos Mesa.
Esto dice Johan Lázaro
Is that your
Ramos
name?
Mesa. ¿Ese es su nombre?
No. What's her name?
¿Cuál es su nombre?
Xiomara Viciedo.
Xiomara Briseldo.
Bicieldo con B corta.
She's doing it. She got
Bicieldo.
it right now.
Does anybody have
Vicieto.
that? Was it? I'm sorry. Oh, yes, it was. I'm sorry, I read the alleged victim's name, excuse me.
Lo lamento, leí el nombre de la
I can't
supuesta
pronounce her
víctima.
name. Vicedo Jori Ziomara.
Cierto,
I
Xiomara,
apologize.
lo lamento, pero no, me cuesta pronunciar su nombre.
Ma'am, this is a magistrate first appearance hearing.
Señora, ¿esta es una audiencia de magistrado de primer grado?
You have been arrested for one count
Usted ha sido arrestado por un cargo de
of criminal mischief.
Conducta criminal.
Give me one moment, please.
Deme un momento, por favor.
Just for the record,
Para los efectos del acta,
I have reviewed.
This is second look. It's not the first.
Oh, this is second look
Yeah,
document?
she came through,
Oh, thank you. How long has she been in custody?
¿cuánto tiempo está?
arrested,
26th of April, yeah.
so, last Wednesday.
16.
Gate, transport, transpire.
It's not our copy.
That's what she handed her.
Was there an offer of sentence?
¿Hubo una oferta de sentencia?
Your Honor, the state's really not in a position to make an offer at this time because the nature of the offense, there's likely restitution issues, which would also normally include a probation order, and probation's a little difficult to issue in this division.
En este momento el Estado no está en posición de hacer una oferta por la naturaleza del crimen. Hay probablemente problemas de restitución y de probatoria.
The
Is the
question,
public defender's office representing her? Or
Señor,
does she have a lawyer?
¿Usted tiene abogado?
Or has she been arraigned?
Your Honor, she actually was transferred to your MI division, and she has a status conference tomorrow.
Oh, she's in my mental health division?
Yes,
Okay, so I'll see her in mental health court tomorrow?
looks that way.
All right, I'll see you in court tomorrow.
La veré en la corte el día
We'll
de mañana.
talk.
Hablaremos mañana.
Okay,
¿Ok?
Oh, ok, gracias.
Ok, thank you.
welcome.
De nada.
De nada.
You're welcome.
Anybody else for the Spanish interpreter? No?
Not at North Crowley.
Thank you very much.
Not at Maine.
We'll return to Conte. Thank you. Thank you, sir. Back to Mr. Brock.
This is,
So what you doing with Rosito?
Going to mental health court?
So transferring the
She's already been
she
transferred.
already, yeah.
She's already been transferred. Apparently she's set.
This is a third,
already set?
That's what I'm.
yes, it's on Odyssey. She's scheduled tomorrow morning for a status in MI. Your Honor, Mr. Brock,
Yes, sir.
the state, Your Honor, the state has filed an information,
Okay. I'm letting Joanne know about
of course,
Samara.
and just checking to see.
I'm listening to you.
Yeah, no, I was just checking to see if an
Oh,
arraignment
okay.
date had been scheduled yet. It has not. He'll go before Judge Robinson, I would imagine, pretty soon for his arraignment.
Okay, fantastic. So that's the route. It's a felony,
Yeah,
correct?
yes, it is.
Okay. All right, you'll have to see your division judge. Thank you, sir.
That's crazy.
Thank you. All righty, who's next?
I believe Kenneth Laws, here at Maine. Mr. Laws, come on up.
Thank you. Thank you very much. I don't mind whoever wants to call the docket. Go.
Oh, I'll call. Yeah. Kenneth Laws on page 6.
All right.
It's Kenneth Laws.
No, I wasn't asking you, Hector.
Oh, I thought I heard someone say, who is this?
No, I was asking someone else.
I don't see him on the docket.
He's on page 6 of the docket. I believe it's a violation of probation, no bond hold.
Oh,
front of Judge
he's
McHugh.
on, he's not second look. He's
Yeah, I think we still have
magistrate.
some regular
We
docket
have regular
cases.
docket.
Oh, yeah.
Okay, got it. Thank you so much. I'd like to do my regular docket before I do the second look, if you don't mind.
Perfect.
So with regards to Mr. Laws, sir, you do have a violation of probation matter. The violation of probation hearing, it looks like has to be set. So I don't have that information for you, I'm sorry, right at this moment, but you will be seeing your division judge shortly. Thank you.
Okay. Good luck, sir.
And
Next.
I have Alexander Patrick Palmer.
Yes, Judge. He's here. Present me.
Thank you so much. And, sir, you have been arrested on 3 counts, 1 for disorderly conduct, 1 for resisting or obstructing arrest, 1 for trespass. I did find probable cause on all counts. Were you interested in resolving your case today?
Yes, ma'am.
You can do that. The offer of sentence would be a withholding of adjudication on the disorderly and trespass. I'll adjudicate on the resisting and no return to that location. No return to that sports bar. And court costs, and how much time would you like to pay? I can give you 6 months.
All right, that's enough.
Thank you very much. You're all set.
I get released today, right?
Sure. Just give me 1 second. I just adjudicated on 2, and the others were withholds.
Are you doing court calls on all 3 counts?
Just 1.
Okay.
Waive on the
Waive
others.
on 2 and 3.
Yeah. Thank you. Carl Clayton, did we call him? No.
Mr. Clayton, come on up. Mr. Clayton's here, present, Judge.
Very good. And Mr. Clayton, good afternoon. You have a violation of probation matter. Your hearing is set for May 3rd at 9 a.m. Thank you very much.
Good luck, sir. Judge,
Yes?
the last person we have at Maine is Ryan Lucero, which is on the docket right before Mr. Clayton. Mr. Lucero is here. That was the gentleman.
Right.
that
I
was
also
this
have
morning.
an Eddie Banks.
Oh, that's on page 8.
Okay. So who did you...
Oh, okay. I was asking if we could address Ryan Lucero.
Is that the individual? Yes, we could, and we had some other matters. Is that what you were saying?
Yes, Judge.
Yes, my understanding, I don't know if Mr. Lunder has the paperwork at this time.
We've been given, did you give the public defender a copy or the new charges? Yeah. No, I have, if Mr. Hodges wants to read my copy, obviously that's fine with me.
Just for the record, I think I have the ad charge as well.
2 and 3?
Yes.
Okay, then yes, you do.
I just haven't had a chance to review it yet.
Of course.
So let me do that now.
Well, and that's a perfect thing. And this is perfect. You'll get to see how I do it. I'll show you when he gives it back.
Okay. So could I clarify something?
Of course, yes, Your Honor. I think I know.
Can you help me just sequentially understand then what counts he is being...
Count 1, Your Honor, is another charge of aggravated battery. And that is tied to the allegations of what occurred at I believe it's a Marathon gas station.
Okay, I don't have that.
That was from this morning. That was
Oh, here
reset
it
from this
is.
morning.
Okay, excuse me.
2 and 3, Your Honor, has to do with what allegedly occurred at the dollar store. The reason that you have a count of murder and a count of attempt is because, as Your Honor is aware, there is no attempted murder statute, and when law enforcement does data entry to put the statute in the booking, what they did is they put the statute for murder and they added the statute for attempt. But either way you look at it, it was law enforcement, the detective's intent to charge him with attempted premeditated murder at the dollar store.
I wasn't talking about that.
Okay, I was just trying to clarify everything. Okay.
Okay, I wasn't talking about that. All I'm trying to determine, because the paperwork that I've got 3 sets of paperwork now.
Oh, you have 3 sets. Okay.
Yeah, I have 3.
Because I just had 2, so
I have 3. So, for example, just to clarify something, I've got, which are different victims.
Yes, Judge.
Is that so? So I just want to make
Oh,
sure.
yeah, it's 2.
Right. There's different alleged incidents, different victims, and I just want to make sure I'm covering everything properly.
Of course.
And then, so the question I have is, okay, so this, okay, I think I've got it. Just
Yeah,
the,
count 1 was an April 29th incident date.
I've got it. And that there was a medical reset, I guess, at one point.
Your Honor, yes. My understanding is, and Michelle can find this better than me, but I'll try. He was scheduled for his first appearance yesterday morning for the aggravated battery, and he was medically reset.
That's it.
And
Okay.
detectives charged him with 2 and 3 since then.
Thank you very much. So let's back up, if you don't mind, to go forward. And Mr. Luciano, first of all, that you have been arrested on 1 count of aggravated battery with a deadly weapon. The magistrate, I guess that magistrate who looked at it but didn't actually.
Yeah, no action was taken.
There was no action taken at the time state. I do find probable cause as to that case, as to that count. And it looks like a purported bond of $20,000 might have been suggested at the time. I don't know.
Your Honor,
No.
yeah.
Okay. Nothing was done.
That might, if it's written there, Judge Benson might have
That was her own
she might have wrote
view.
that preliminarily before,
Understood. Just for the record, let's start from the beginning, strike everything for the record. I do find probable cause as to the count of aggravated battery with a deadly weapon. This is the 4/29/17 arrest, and I'd like guidance, first of all, with regards to proposed bond.
Your Honor, on the aggravated battery, the state is going to be requesting a $50,000 bond and no contact. That's taking into light that he's already out on a burglary. Additionally, Your Honor.
He's out on a burglary?
Yes.
He's out on a burglary of an unoccupied conveyance. That case is in Judge Porf's division, case number 16014115 CF10A, which at this time pretrial will be requesting a revocation of his supervision, Your Honor.
I'm going to go ahead, just for the record, and revoke that pretrial release order on 16014115 CF10A. That is, he's going to be held no bond.
Additionally, Your Honor, this appears to be a high level of violence with no provocation. This appears to be over a cigarette at a gas station where he allegedly attacked the clerk with a 3-foot wooden stick in the head. And then also taking into consideration, the allegations are the day before allegedly stabbing a clerk at a dollar store with a knife. So,
$50,000 bond as to the aggravated battery with a deadly weapon. Obviously, no contact, no return. With regards to the ad charges that were presented to the court this afternoon, the defendant has been arrested on 1 count of premeditated murder, as well as 1 count of criminal attempt to solicit or conspire a life felony.
what I'm going to be asking the court to do, and this, I got a little ahead of myself. Your Honor, I'm going to be asking the court, whatever finding you make, on count 2, it should be attempted murder. The reason it says murder premeditated, there is no attempted murder statute, so they have to put in the statute number for murder. But it clearly was the intent for attempted murder. Your Honor, the state is going to be seeking a no bond hold on both counts. They are both essentially punishable by life offenses. Your Honor, arguing the evidence of such is, one, the premeditated nature that Mr. Lucero went to the dollar store specifically asking for the knives. When he was told where they are, taking the knives, I believe he went to the bathroom, removing them, and then immediately upon first seeing the clerk, he repeatedly stabs her in the chest, shoulder, and back, Your Honor, repeatedly stabbing her, woman using her hands to defend herself. Additionally, this incident was caught on a surveillance video in the store, and Mr. Lucero's father identified him as the person committing the offense from photograph images taken from the surveillance video, Your Honor. So I believe the state is not required to file a pretrial detention motion. The state can seek a finding of proof evident or presumption great for first appearance. I believe for first appearance purposes only, the evidence satisfies that burden. The defense, no matter what, if Your Honor decides to hold Mr. Lucero no bond, the defense can obviously seek an Arthur hearing in division. I also believe, taking these two instances together and considering that he was already out on a felony offense when committing them, I believe that Mr. Lucero poses an extreme danger to the community, and I do not believe that there are any alternate conditions of release other than detention that can ensure the safety of the community.
Defense? Did you want to
Yes, Judge. Judge, in speaking with Mr. Lucero, first a little background as far as regarding count one, as far as the $50,000 bond. Financially, he's not in a position post-bond. He's on disability. He does have mental health issues. He's been residing in South Florida most of his life. He's 23 years old. Judge, he cannot afford anything close to that $50,000. That's tantamount to no bond on Mr. Lucero's
First of all,
behalf.
he's already being held no bond. Let's just get something straight. He's already being held no bond. He was out on pretrial release on the felony matter, and I revoked that. And
Correct. You just
he's
revoked it
already
right
being
now.
held no bond.
On case number 16014115 CF today, my understanding is that that case is still filed. I don't know if the state can confirm that or not. I would ask you to take that into consideration on an
He's being held
unfiled
no
case.
bond, and I'm going to hold no bond on this as well. Thank you very much.
Okay, well, Judge, if I can continue as far as now in reference to count 2 and 3, you're holding Mr. Lucero no bond. Everyone that appears before you, Judge, is entitled to a bond. There's only two ways a person can be held no bond. One is if the state goes ahead and files a pretrial detention motion, which they said they're not. So therefore, now the only other way the state can, this gentleman can be held no bond is by the state asking you to find proof evident presumption great. That's what they're asking you to do at this time. Judge, that's the highest standard of law we have in our land. We're asking you at this time that there's not sufficient information, facts, no one came before you as far as to testify or anything like that. We would ask you not to go ahead and find that standard and impose a reasonable bond on Mr. Lucero's behalf.
And, Your Honor, if I may, just for record purposes, one, the 4th ECA has previously ruled in Brackett v. State that the state can rely upon affidavits at a bond hearing in satisfying proof evident or presumption great. And I would also note that while the public defender is making a general objection to proof evident or presumption great, Mr. Romero has not made one argument to refute the evidence that I specifically noted on the record.
Thank you. This is what I'm going to do. I'm going to set, it's fine. You know, I would set $500,000 on both counts, each count $1 million with regards to the attempted murder count as well as the criminal attempt. Thank you.
And, Your Honor, just in an abundance of caution, we ask for no victim contact.
Of course.
Judge, 3 other things. If you could sign an order allowing us to photograph Mr. Lucero's injuries. Number 2, if you could, considering there's mental health issues, would you sign an order appointing the Office of Public Defender on Mr. Lucero's behalf?
Sure.
And number 3 would be invoking his right to remain silent
course.
and not be questioned by law enforcement.
Yes, on both counts with
Thank you,
regards to
Judge.
the Public Defender's Office. And, yeah, thank you.
Thank you.
is that it for this afternoon?
I think we have a
Thank
second
you,
look.
Judge.
Good to see, I'll see you tomorrow.
I haven't.
Thank you.
I still have somebody on the second look docket, Your Honor. I have Eddie Banks.
Oh, that's right. Where are you? North Broward?
I'm North Broward, yeah, and I also have
That's
one
you.
on the second look
yes,
docket,
of
too.
course. You're
Come on
right.
in,
Mr. Banks is here. Thank you. But it's not a second look, is it? It's a VOP. Mr. Banks?
Yeah, he's on just the second look, and then I have another one on the 235 docket. But he's on just the second look docket.
Okay,
He's
is
the
that
last one
Mr.
on
Banks?
That's Mr. Banks right here.
Mr. Banks, you have 8 counts of violation of probation. You'll be seeing your judge on Monday, May 8th at 8:45. Thank you.
My appearance is under duress, and I'm making the statement that I am the authorized representative and executive owner for the defendant. I'll give the court notice as to public record number 11065.
Thank you very much. You're all set. Thank Anybody left?
Well, we got a bunch of 30 days.
The deputy's saying there's one more person left.
No, he's on the second look docket. I don't know if you want what order you want to go on that, but I have a Mr. Derek Ponder.
Okay.
This is a 30-day motion for release, Your Honor. I'm just checking to see if we state file charges.
Derek Ponder.
How
Is
you
that
doing?
you?
How you doing? Yes, ma'am.
Thank you.
Your Honor, the state has not yet filed an information. Mr. Ponder is entitled to release on these charges at this time.
The court will order your release on these charges at this time. It does not mean the charges will not be filed in the future, correct?
Yes, ma'am.
You understand that?
Yes, ma'am.
Thank you.
Thank you. Have a nice day.
Thank you.
North Broward's completed, Your Honor. I'll see you
Very
tomorrow.
good. You did a great job. Thank you.
Thank you.
Copy,
Your Honor.
Your
Yes.
Honor, Paul Ryan has
We got
4.
Gregory Moore.
I have 1 on the second
George
look
Moore.
and
George
1
Moore.
and 3 where the charges were not filed yet for Paul Ryan.
Okay. You can help me call them if you like.
Okay, great. I'm going to give you
calling,
Samia Austin.
George
Samaya
Moore.
Austin. Come on up.
Is that Confi?
It's
Samaya
Paul
Austin is on
Ryan.
the second.
Oh, we're at Paul
Yes,
Ryan?
ma'am.
Okay.
We're at Paul Ryan.
Who is that standing there?
And you are?
Samaya.
Okay.
Last name is Austin.
Austin. Last name is Austin.
She's got 2
ALSTON.
second looks on a misdemeanor. It's one case. They split it up because one's an MO charge.
Okay, just tell me
one's
about it.
Prostitution and possession of cannabis.
Thank you. And how long has she been in custody?
She was arrested 6 days ago, last Wednesday.
Okay. Was there an offer of sentence?
Obviously I can't make an offer on the municipal ordinance. If she wants to resolve the loitering for prostitution, state's offer would be adjudication. Oh, I'm sorry, the state charges of possession of cannabis. I'd offer withhold. Court cost judicial notice time served. And
You'll make it a withhold on both,
well, I can't make an offer on the MO, the municipal ordinance.
which is the prostitution charge?
Yeah, that's the loitering for prostitution. All I can do is make. I mean, but certainly the court.
Ma'am, were you interested in resolving your cases today?
Yes, ma'am.
Okay.
Yes, ma'am.
If you wanted to resolve your cases today, you can. The offer of sentence would be withholdings of adjudication on both the prostitution charge as well as the possession charge. With the prostitution case, there is a requirement of an HIV STD blood screen, not the results. That's private to you. Court costs, but I would give you 9 months to pay court costs. They're expensive on the prostitution charge. And as a legal advisement, it's very important to know that if you are not, and I'm not asking for comment, if you're not an